Hey, and welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. My name is Tim Sechler. I am the owner of the Sechler Law Firm. I am here doing this show each and every week, giving you the things you need in order to make great estate planning decisions for you, for your family, for your finances. And today I want to chat about planning for your kids. And whether your kids are little guys or whether your kids are adults, why you love your kids way too much than to give them an inheritance outright. And as we get into this episode, I want to just like kind of give you some background for why we do what we do. So, the estate plan law firm that I own, SechlerLawFirm.com. We do estate planning, and we started this business to help folks with this specific issue, and that was what happens if I am one of the three people who ends up with dementia? I'm one of the 2 out of 3 people who ends up needing nursing home care. So I got a 1 in 3 chance of having dementia. I got a 2 in 3 chance of needing long-term care. And for some of us, 20% of us, according to longtermcare.gov, 20% of us, we're going to need that care for more than 5 years. Okay. Now, I started the law firm to wrestle with this issue about estate planning is about more than death planning. Estate planning is planning for where am I going to live? How am I going to pay for it? Who's going to take care of me? Is it really going to be my kids? Do I actually want my kids to be the person changing my diaper, or would we rather have somebody paid to do that? And if it's going to be somebody paid to do that, then what's our actual plan to make that happen, right? Because people go into this whole situation with their head in the sand about how much it costs and who's going to pay for it, is Medicare, Medicaid. So we got into this space. I started the law firm to help people better understand estate planning and elder law issues like asset protection from long-term care expenses, how to get your care without going broke in the process, et cetera. And as the practice has developed over the last decade or so, it's become predominantly an estate planning practice. Not just dealing with people that are in nursing homes and dealing with that issue, but we do an awful lot of work for families who are just planning for the future. And yes, the nursing home is one of those issues that people plan for, and we still need to plan for that. But as the practice unfolds, there's a couple other things that have tended to sort of like come into this. And in estate planning is greater than death planning, right? Estate planning is not just about death planning. But it's not just, but to the same extent, it doesn't just end when you pass away, right? Your estate plan will outlive you. If your estate plan is done properly, it's going to outlive you, and it's going to honor your goals. It's going to honor your values, not just your valuables, not just the money. It's not just about the money, but it's going to honor your wishes for your family and how they're gonna live their lives, and it should do so for a long time. But here's the challenge: there's plenty of speed bumps in the road that would disrupt your plans, right? You probably have this idea in your head about living forever, and I'm gonna leave someone to my kids, and of course, nothing ever bad happens, right? I mean, nobody ever passes away young, or when we do pass away, nobody in our family is sick or disabled. None of that stuff ever happens. It's more about just making sure we give them the bag of money. But the problem with this is you can't just give them a bag of money, right? If you're listening to this show, you're an adult, you have a job, maybe that job came with a retirement account, you have an IRA, a 401k, a 403b. Well, here's the thing about those accounts. They are all beneficiary designated, which means for way more than 9 out of 10 people, you've just got a human as a beneficiary on that IRA. Well, why is that? Nobody ever thought this thing through, right? But we've got these IRAs that are beneficiary designated, which means if I inherit an IRA from a loved one, if a family member passed away and leave me his or her IRA, I just get that IRA account. Now, here's the interesting thing about it is if I get that outright, it is now subject to my creditors, my predators, a potential divorce or lawsuit that our kids may go through. If the money comes in my name, then it's subject to the kids' issues, right? So I want you to think about this. Maybe you have adult children. Maybe you've got minor children. Is giving them the inheritance outright the best decision, right? Is giving them the inheritance outright the best decision? Are they in a happy marriage? Do we even know if they're in a happy marriage? your child might be happy. Is the other person happy? Or is there any disability in the family, right? Because one of the things that happens is if I receive an inheritance and then my wife files for divorce next week, no judge is going to give her that money. If, however, I receive an inheritance and then for the next 5 years I pay off our mortgage on our jointly owned house and pay off student loans and pay off the car loan on our jointly owned car, and then I put the rest into a joint account where we use the thing for like home repairs and vacations and whatnot. And then 5 years later she files for divorce. Now what happens to the money? And we can't even tell whose is whose anymore, and it all gets very confusing. So this divorce issue amongst our clients, that are concerned about like what are the things that could take money from your family. One is taxes, one is the nursing home, one is undue legal fees, but one in a major way could be what happens if there's some marital disruption in your family, not necessarily your wedding, but your marriage. But if you leave money to your kids and then they become divorced, what happens to the money? And I got a lot of our clients that are concerned about this, so much so that we plan for this sort of as a matter of course now. And I want to explain how we do that, and I want to explain why this is one of those things where you can't just say all I need is a simple will, right? Um, and here's how it works. Whether you do a will or a trust, we tend to do a lot of trust in our law firm. You create a trust. Now, when you pass away, what most estate planning documents do is they say, give it to the kids. You give it to the kids outright, equal shares to my kids. So now we got this bag of money. We're going to divide it by the amount of kids you have. We're going to put it on, and we're going to give them, we're going to walk into their house, put this bag of money on the figurative kitchen table. But what if the house is on fire? Should we still put the bag of money on that kitchen table? What if there's a tornado coming? Do we still want to put the bag of money on the kitchen table, or should we do something else with it that protects it from that divorce tornado? And what we like to do at our law firm is we don't like to give the inheritance outright. We give the inheritance in a trust. So each kid receives their inheritance in their own little trust, right? And that little trust has the money in it, and then your kid is in control of the trust, and your kid can have access to the money in the trust. But we've got this great law in Pennsylvania that says if the inheritance is in a third-party testamentary trust, which is technically what this would be, we've got this great law that says that so long as that trust is subject to what's called a spendthrift clause, meaning the person I'm leaving it to, their creditors can't get to it. So long as it has a clause in there that says that the creditors can't get to it, it turns out in our trust code, the trust code says if it has that clause, the creditors really can't get to it, right? It's right in the trust code. And so what we like to do is we like to give the inheritance to the kids in a trust that they can be in control of. They can access the money. They can invest the money however the heck they want. But when they pass away, or not when they pass away, but when if they're ever divorced, if they're ever sued, it would be outside the reach of those creditor claims. And this to me just makes more sense. And for your adult kids, is probably a better way for them to receive the inheritance. And if they are the 100% beneficiary, then they could probably just distribute all the stuff to themselves if they don't like it in the future. But I want to encourage you that you love your kids way too much than to give them an outright inheritance, because if they've got something going on in their world, like a divorce, like a lawsuit, or something like a disability or a bankruptcy type thing coming along, now we can give them their inheritance in a way that's safe from a lot of that stuff. And it's just a better way to do it. So why wouldn't we do it? Well, because people never go out and take the time to become educated on their options. You've been told by someone, the world has conspired to tell you that you're not rich and all you need is a simple will. You've probably heard it from your financial guy or your banker or your lawyer or the legal Zoom commercials. You're not rich, all you need is a will. Well, yeah, okay. If that were true, then that's like planning for we all grow and live until we're 95 years old and pass away and leave it to our kids, and they're all going to live in happy marriages until they're 95, and no one's ever disabled, and no one ever gets a divorce, and no one ever passes away young, and none of that bad stuff ever happens, right? I mean, do we really want to plan to live in a world that is not real? Because that's not real, right? I mean, that stuff happens in families. Um, Or do we want to plan for the real world? And if those types of things are happening, I got to plan for it. That's been my take. If we're going to do this, why not do it right? And I think one of the issues is because people just don't understand their options, right? You go to the lawyer's office or you do the thing on the internet, and it just says all you need is a simple will. Well, okay, but what about all these other questions? You know, what about the other important questions? Not just who gets it when I pass away, but what happens if there's something going on in their world? What happens if they're going through one of these things? And if we take the time to create an estate plan, a will or a trust that creates this infrastructure to protect your kids from those things, well, now your money actually gets to your kids in a format that they can enjoy it, but no one else can. And to me, that's just much better planning. But here's the problem, right? Well, before I do the next problem, this is the type of thing that we teach you at our estate planning and elder law workshops. It's called the 3 Secrets to Protect Your Legacy. You can sign up for it. We have them all around the Pittsburgh region. Sechlerlawfirm.com, Secler lawfirm.com. You can go to the workshop. You can learn about these different tools, how we do the planning, the way that we do the planning, and you can decide if it's right for you. I mean, my promise to you is you will make a well-informed decision. Even if that decision is that you don't want to work with my law firm, I hope you have the right information to make that decision. What I will not do is I will not sit you down in a 1-hour consultation and try to design your estate plan without teaching you the options. I want you to know your options before you make a decision. And that's why we do the education for free in the workshops. We teach you all this stuff. Okay. Here's the other problem, right? Estate planning and your kids' success after they receive the inheritance, your kids' well-being, has largely been dictated to you by the IRS. Now, how's that true? What's the IRS got to do with the way my kids get an inheritance? Oh, he must be talking about death taxes, right? We're talking about death taxes? No, not really. Most people don't pay death taxes. You can pass away with an awful lot of money before there's any death taxes. That's not really what I'm talking about. What I'm talking about is about 50 years ago, there was this collective effort amongst large employers and the government officials that we had to get away from pension plans. We had to get away from defined benefit plans and put the money instead into this thing like a defined contribution plan, like a 401k, right? Because the companies didn't want to be on the hook for all these pensions forever long a person live, defined a benefit plan. But they can save their own money, and if they save enough, then they'll have enough for their own retirement. So why don't we just do 401ks and IRAs? And there's some wisdom to it, I suppose. And so the IRS went along with this whole thing. And the IRS then created this section 401k in the trust code, which governs 401k plans and IRAs, and then the 403bs that came along, and now the other stuff that are these tax qualified accounts. Okay, so what happens? Well, you go to your employer now who didn't want to pay for a pension. The employer is now saying, well, we'll run a 401k and we'll give you a match, right? So if you'll put in 4% of your paycheck, we'll match that 4% of your paycheck. So you essentially had an opportunity to give yourself a 4% raise, and everybody did it because I'll take a 4% raise, and then I can take that 4% and collectively now 8% of my paycheck, put it into a 401k plan, and I don't even have to pay taxes putting it in. Like, this is kind of a neat thing. And so now the money's in this 401k plan, and it can grow tax deferred. So now I'm making money on the money that was never taxed in the first place. And so all the money started getting plowed into these accounts, right? And so for the baby boomer generation, your entire generation, you've been plowing money into 401k plans, IRA plans. Like, that's where the money is. I see balance sheets every day. For the baby boomer middle class generation, the money is in home equity, in retirement accounts, and then some people have some other stuff. But that's where most of the money is. All right. But here's the thing. Because of the tax deferral on these accounts, there's some restrictions on these accounts. And there's this thing that used to be the case where your kids could receive what's called stretch IRAs, a lifetime IRA, an inherited IRA. So if my dad would die and leave me an IRA, let's say my dad would leave me a $200,000 IRA. I could take dad's IRA, I can invest it. It would act a lot like it's my IRA. I'd have to take a little bit out every year, but we could let this sucker ride and we could let it ride and we could let it ride until my retirement years. And then once I retire and I'm in a lower income tax bracket, then I could pull the money out of the account. Okay. And that was a pretty sweet situation. And so they took it away in the year 2020 with this thing called the Secure Act, where they took away inherited IRAs. Now what happens is um, when my dad passes away, if he would leave me a $200,000 IRA, now I have to pull all the money out within the first 10 years after he passes away, right? Which is a giant tax squeeze, right? I mean, they flat out stole your retirement accounts. And it essentially created this new death tax on the middle class. I mean, that's what this law called the Secure Act really was, right? They wanted to get to the IRA money. They didn't want to take it from you during your life because that would be politically unpopular. And so let's pass a thing called the Secure Act. And the Secure Act, boy, that sounds like a nice sounding bill. Who would vote against the Secure Act, right? So they passed this thing called the Secure Act. But all it did was stole the IRA money from your kids after you pass away, rather than getting 30, 40 years of tax deferred growth on the money like they promised you your kids would when you invested the money. Now what happens is your kids have to pull all the money out in the first 10 years and get smoked on income taxes. Okay, so you should be livid about that. We've done shows in the past on the Secure Act. That's really not the purpose here. But here's the purpose here. Even with the Secure Act, you still get 10 years, right? But if you leave an IRA to a non-human entity that is not structured the correct way, you only get 5 years. So especially when it was lifetime stretch, the financial world, the legal world was very concerned about not leaving the IRA money directly to a human because we don't want to lose the lifetime stretch. Now we don't want to lose the 10-year stretch. So the mindset, the collective mindset in the financial and legal community developed to say, well, we'll just leave the IRAs to the kids outright because they'll get that stretch and all that, right? But here's the problem. Here's the problem. The tax tail is wagging the dog in some respect, because now we lost lifetime stretch, and we're leaving it to the kid outright out of concern about the tax ramifications. But if I leave it all to my kid and my kid goes through a divorce or my kid gets sued in those 10 years and we lose the money to that issue, well, now what, right? So because the tax law encourages you to leave your retirement account to a human, you lose the opportunity to do the good planning that would protect it from disabilities and underage and divorce, because that's just the way, and other creditors, that's just the way that it happened. But it's not really the case. I'm here to tell you, you could remember this trust for your kids I was talking about. You love your kids too much to leave them the inheritance outright. Those trusts that you could set up for your kids, well, it turns out, if it's structured properly, and please don't do this without the help of a lawyer, but if it's structured properly, you can leave those assets to a trust. And then that trust can benefit your kid, and then the tax ramifications don't have to be bad if it's done correctly. This is real planning, right? This is the difference between checking some box that says, oh, I got my will, and actually having a good estate plan. Because this is the whole fallacy of all you need is a simple will. Well, simple wills don't govern what happens with retirement accounts and life insurance policies and annuities and other accounts that have beneficiary designations. So I could write you like the world's best will, and it could have all these trusts for the kiddies and protect from disabilities and death and divorce. But then you go around the will and leave all of your money to your kid via beneficiary designation. You leave that money outright to your kid, and that's 80% of your net worth. And you just exposed 80% of your net worth to the disability and the divorce and all the rest again, right? And so a well-structured estate plan is not just a document and slapping some beneficiary designations on an account. A well-designed estate plan, the beneficiary designations and the estate plan work together to accomplish your objectives. Now, as you can tell, this stuff can get pretty complicated, which is why nobody's ever told it to you before. Because look, death and dying isn't fun to talk about anyway. I certainly don't want to talk about your kid getting a divorce or your grandchild becoming disabled. That's uncomfortable. And it's uncomfortable and complicated, right? So if I can say, like everybody else says, all you need is a simple will, well, that's easy to say. That frees me, the advisor, from having to talk about disability or divorce, and or what happens if your wife goes to a nursing home. So it's easier for me to go with the company line that is all you need is a simple will, and that'll work. It's easier to do that than it is to say, no, 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 no. There's some other things we need to plan for here. There's some other opportunities that this person would like to probably take advantage of if they understood it. If they understood it, how they could protect their kid from disabilities and death, if they understood how they could protect their young grandchildren from making major mistakes by putting some protection in place, if they understood how to do that, they probably would. But most firms don't take you through that educational process. Education is a passion of mine. And that's why I have a free radio show where I get on and I give you tips like this. That's also why our first step in our workflow is to invite you to an educational workshop. The workshop is not designed to sell you anything. You cannot write me a check at the end of the workshop. We're not selling anything. It is a workshop that is designed to explain the difference between the will and the trust, the revocable living trust, and the asset protection trust. It is an educational event to give you the information you need in order to make some estate planning decisions. And we've been doing these workshops now for a couple of years, and they're very well received. People learn an awful lot of great information about it. You learn the different tools. You learn about powers of attorney and wills and trusts. Learn about how this long-term care, Medicaid, nursing home system works, how you can protect yourself from those expenses. We teach you all this stuff. Once you have the information in front of you, then you can make a well-informed decision, which might include hiring my law firm to do your estate plan, or it may not if you don't want to hire my law firm. I still want you to have the education, right? And so I would encourage you to go to sechlerlawfirm.com, SECHLER lawfirm.com, and register to attend one of our upcoming 3 Secrets workshops. These workshops are great. We get 5 out of 5 consistently on these things. You learn a bunch. We tell you what our workflow looks like. We tell you ultimately what it costs, but you cannot hire me at the 3 Secrets workshop. We don't even bring fee agreements to the thing. It is an educational event. You do learn how our process works. You do learn about these documents. You are invited to come back later and engage our law firm if you would like, but you will not be pressured into writing a check at this workshop. So come check it out. Learn all these different tools. And while we're on the subject of leaving stuff to your family members in trust, I just want to mention that this isn't just a baby boomer and senior conversation. If you're listening to this show and you have grandchildren, adult children who have kids, or if you have young children yourself, this is you too, right? Because what lots of parents do when they have little kids is they start investing the money in the retirement accounts. But what lots of young parents do is they go out and get life insurance. Like if a young person, a young adult parent pass away in an accident, often the money is in the form of group life insurance from work or term life insurance, because we could get it cheap. And if I pass away, I need to take care of my kids. So one, most young parents don't have enough life insurance. That's a topic for another day. But second, what most everybody does with that life insurance policy is they say all to my spouse if I'm married, and then to my kids. Okay. But what are we really doing here, right? All to my spouse, that's probably okay in some situations. But all to my kids, if I'm out on the road with my wife, let's say my wife and I score a babysitter, and we go out on a date, and some drunk driver runs through our car and takes us both, right? Life insurance outright to my kids. My youngest is 8 right now. We really should do life insurance to an 8-year-old? Well, they're not going to get it. They're going to get it later. But who's in control and at what age? Are they going to get it on their 21st birthday? My goodness, if I'd have got that kind of money on my 21st birthday, I don't think I would have made great decisions. I don't think I would currently be in a position I am to be talking to you about this stuff. And so I think if we're gonna do this, guys, it's worth doing correctly. And that means that young parents need to do good estate planning too. And I'm excited that we have an upcoming estate planning workshop for young families as well. So give us a call. Go to sechlerlawfirm.com, Secher lawfirm.com, or give us a call at 724-841-1393 to learn more about that young families workshop. I hope you enjoyed the episode today. Listen, guys, don't make any decisions on your finances or on your legal affairs based on what you hear on this or any other radio show. This is for your education. This is not legal advice. If you need some help, you need to go get some legal advice. We're available at sechlerlawfirm.com. Thanks for listening.